I'm Calvin Koo, and this is your July 2023 crypto update. As a reminder, my thoughts and comments are strictly my own and not that of my employer. Nothing I say is intended as legal or financial advice. We've often talked about the Financial Action Task Force, or FATF, in this series, as their guidance and reports on recommended virtual asset regulations for anti-money laundering are widely influential on various jurisdictions, even if unevenly executed or enforced by those jurisdictions. Last month, FATF published its targeted update on implementation of the FATF standards on virtual assets and virtual asset service providers, or VASPs, basically making the point that there's a long way to go for jurisdictions to match FATF's requirements. In this update, FATF notes that it has been 4 years since FATF extended its global standards on anti-money laundering and counter-terrorist financing to apply to virtual assets and VASPs. FATF notes that, quote, some of the more significant virtual asset markets in terms of materiality and scale of virtual asset activity have AML-CFT regulation in place or in progress. However, it is a serious concern that 75% of jurisdictions are only partially or non-compliant with FATF's requirements, end quote. FATF further notes that this puts compliance behind most other areas of the financial sectors. FATF undertook a survey with 151 respondents. It found the following statistics. Over 1/3 of the jurisdictions that responded have not conducted a risk assessment for virtual assets and virtual asset service providers. 73% of the remaining did not conduct adequate risk assessments. And 60% decided to permit virtual assets and VASPs, and 11% opted to prohibit VASP completely, though evaluation of that prohibition suggests it is difficult to prohibit effectively. Now, one of the key FATF guidelines involves the travel rule, which we've discussed in prior videos. As a reminder, in short, the travel rule requires VASPs to obtain and disclose information pertaining to the sender and recipient of a virtual asset transfer to counterparties. This has some technical hurdles in many cases of virtual asset transfers, especially when dealing with a counterparty that is not at a centralized institution. FATF says that jurisdictions have made insufficient progress on implementing the travel rule, leaving virtual assets and VASPs vulnerable to misuse. 50% of survey respondents, excluding those that prohibit VASPs, have taken no steps towards travel rule implementation. FATF adds that this group is expected to be even larger in reality, as it's likely that they should also include 54 jurisdictions that didn't even respond to the survey in the first place. So basically, there's not been enough travel rule implementation around the world. FATF acknowledges that the situation is evolving, since at the time of the survey, some of the legislation now in place had not yet been made effective. So, for example, it cites the EU's new MiCA legislation that does implement the travel rule. That said, FATF also points out that even among jurisdictions implementing the travel rule, supervision and enforcement is low. Only 13 of 62 respondents issued findings or directives or taken enforcement or other supervisory actions against VASPs focused on travel rule compliance. Commenting on private sector innovation, FATF says that there are a range of technological tools to enable VASPs to implement the travel rule, but that those tools generally do not fully comply with FATF's requirements. So a lot of ground still to make up. As for general risks, FATF again cites things like the following: decentralized finance and unhosted wallets, including peer-to-peer transactions, which some jurisdictions reported can be hard to identify specific natural or legal persons responsible for VASP obligations. This is not surprising because decentralization is at the heart of the blockchain technology that underlies this ethos of cryptocurrency transactions and other virtual asset transactions. Sometimes you just don't know who's on the other side and thus who's responsible for these obligations. On this, FATF calls for jurisdictions in the private sector to strengthen efforts to monitor the risk that decentralized finance could pose money laundering and terrorist financing risks, as well as share approaches and identify challenges to mitigating those risks, in addition to implementing FATF standards. Again, I think all of this sounds easier said than done, but many are working on it, so we'll see how it develops. Finally, FATF also cites concerns about North Korean and terrorist groups' illicit activities involving virtual assets, as if to underscore the consequences of not implementing FATF controls. Appropriately, FATF concedes that the vast majority of terrorist financing still uses fiat currency. Moving now to regulatory developments in specific parts of the world, starting in Singapore. And really, this relates also to a FATF-inspired development. The Monetary Authority of Singapore recently announced a consultation period for proposed amendments to the payment services regulations to further align with FATF's enhanced anti-money laundering standards applicable to virtual asset service providers, or what Singapore generally refers to as digital token service providers. For the purposes of this video, we'll consider it similar things. This follows legislative amendments to 2021 to expand the scope of the Payment Services Act to include digital payment token services, among other things. Those amendments, although passed, were not yet operative. So this consultation proposes further amendments to make it operational. Among the proposals are requiring relevant licensees and other service providers incorporated in Singapore to develop and implement group-wide AML-CFT policies, including for sharing information required for customer due diligence and AML risk management. Separately, the Monetary Authority of Singapore said this month that they would require digital payment token service providers to safekeep customer assets under a statutory trust before the end of the year. This is to mitigate risk of loss or misuse of customer assets and facilitate recovery of those assets if the service providers become insolvent. Following a public consultation, there reportedly was broad support to require service providers, to segregate customer assets from its own assets and held in trust, safeguard customer monies, conduct daily reconciliation of customers' assets and keep proper books and records, maintain access and operational controls to customers' tokens in Singapore, ensure that the custody function is operationally independent from other business units, and provide clear disclosures to customers on the risks involved in having their assets held by the virtual asset service provider. The Monetary Authority also will restrict service providers from facilitating lending and staking of tokens by retail customers. Those who are following the market know that these are all clearly issues derived from major loss areas for crypto investors and traders during last year's crypto winter. Tokenization. This is one final story about the Monetary Authority of Singapore related to it. They also published a report in late June covering best practices and technical standards regarding decentralized protocols and the trading of digital assets across networks and liquidity pools. It calls this effort Project Guardian. In their June report, the Monetary Authority said that, quote, the real value in the digital asset ecosystem comes from the representation of real economy and financial assets digitally in a tokenized form using smart contract technology to enhance efficiency, accessibility, and affordability of financial services. Once represented as digital tokens, they can be exchanged readily and used to facilitate more efficient economic transactions across pre-trade to post-trade capital market activities. So, expecting this to be a growth area, this report then introduces a framework for designing open and interoperable digital asset networks based on tokenized real economy assets and financial assets. This indicates Singapore's continued commitment to finding a responsible framework to allow this young blockchain technology to grow and thrive, notwithstanding crypto winter, which arguably were backed by no real or traditional assets, unlike the tokenization of real-world assets as expressed here in this paper. Moving on, as we've discussed, Hong Kong is also pushing to be an Asian and global hub for virtual asset service providers. The regime that just started in June, which we've discussed, does not cover stablecoins, however. Nevertheless, the Hong Kong government recently announced that they are committed to introducing stablecoins regulation by 2024. This past January, the Hong Kong Monetary Authority announced plans to implement a stablecoin licensing regime with requirements of having fully backed reserves for the token. Then, in June, the Secretary for Financial Services and the Treasury echoed this intention, as did the Director for Licensing for the Securities and Futures Commission. The SFC and HKMA will reportedly collaborate in this effort, even though they'll have separate policies, so as to ensure no or minimal overlap and consistency with how to deal with it. So basically, you have three agencies seemingly working towards the same goal regarding stablecoins, and they're doing so apparently collaboratively. Now, an update on an ongoing court case in the US that has significant ramifications for crypto there and perhaps beyond. A significant decision was handed down in the SEC, or the Securities and Exchange Commission's case against Ripple last week. As in other major SEC regulation by enforcement matters, the SEC accuses Ripple of unregistered issuance of securities, namely the XRP token, as well as allegations against the founders for aiding and abetting those violations. An analysis of whether XRP is a security under traditional US securities laws is at the heart of the case. Now, we've talked before about the Howey test standard, which is used in the US to determine if something is an investment contract. If so, it's a security and must follow relevant securities laws. And as we've discussed here, the SEC basically views every digital token as a security other than Bitcoin and maybe Ether. While in older enforcement cases, many issuers settled with the SEC on these, is it a security, is it not question, and they often settle for a fine rather than test the SEC's theory all the way to trial, Ripple took a different approach, fighting ahead with support from many in the crypto industry. Because it is being fought in court, this has the chance to set important precedent for other similar cases dealing with this question of whether crypto is a security, or all types of crypto are a security. Now, in this Ripple case, we reached the summary judgment stage of the proceedings, with both sides filing motions for summary judgment, basically each side arguing the facts were such that the judge should just decide the case in their favor now. Instead, the judge issued a split decision last week. A July 13th, 2023 order in that case applied the Howey test to the particular facts of the XRP issuance and found that the XRP sales to institutional investors did meet the Howey test elements, and thus it was an investment contract and therefore a security. The court also found, however, that the XRP sales through crypto exchanges, which were done through algorithms, failed the third prong of the Howey test because that required the buyers to have known that their payments went to Ripple. But really, the way this payment setup was arranged through crypto exchanges, those buyers, according to the judge, could not have known if their payments of money went to Ripple or any other seller of XRP. This split decision, which is still open to a full trial and appeals, leaves open how Howey applies to particular digital tokens. But on balance, it seems helpful to the crypto industry that there is no blanket determination that all cryptocurrency or other digital tokens are securities, contrary to the SEC's perspective. Finally, one other story from the US. The US government set up a new task force comprised of 5 federal agencies, formalizing an existing cooperative framework to combat crime related to crypto, particularly how criminal gangs use it for things like money laundering, drug trafficking, child exploitation, and personal data theft. This is called the Darknet Marketplace and Digital Currency Crimes Task Force, and it brings together Homeland Security, the Department of Justice, the Internal Revenue Service Criminal Division, the Postal Inspection Service, and the Drug Enforcement Agency. That's it for this month. I'll see you next time.